hear from the appellant when you're ready.
And I'd like to reserve 3 minutes.
That'll be fine. Thank you.
Good afternoon to the court. I'm Randy Sellers. I'm from the Bradley County Bar. I represent Nathaniel Carden and his parents, Jeff and Jackie Carden. This is an unusual case in that it has 2 petitions pending at the same time. These parties, Nathaniel and Mom, were divorced in 2018. There was a parenting plan that went down on default against Dad. Dad got 0 days based on the parenting plan, except that he could receive supervised visitation at a supervised visitation center in Bradley County. From then after, Mom and Dad's parents developed a nice relationship after the divorce. By need and by agreement, Mom would allow the children to be with the grandparents by everyone's testimony about 2 to 3 weekends a month, plus other events such as camping, going to big wheel events, going to baseball games, doing other things, other activities. And during that time, with Mom's knowledge, Dad came back in and was blending with his children and establishing a close relationship with them as well. It's a little bit of contest by Mom as to whether she knew about that, but we think the evidence did show that she was aware that Dad was visiting with the children during that time. So this goes full circle with that relationship until 2021. That time, Dad learned, I guess through the grapevine, that Mom was going to move. And it'd probably be safe to say he learned it from the children, but in any event, Dad files a petition, the original petition in this case, basically asking for a restraining order to prevent Mom from moving, and that restraining order was granted. Mom filed a counter complaint requesting that she relocate with the children. And by the way, in the original petition, there had been no compliance with the relocation statute as to statutory notice, 60 days intent to move, that type of thing. And really that notice only came about when her counsel for her filed their counter petition asking for relocation and in essence stating those things within the pleading. So from there forward, before the case was heard, the grandparents intervened. I've already told you a little about their relationship with the children, but they intervened when upon the day that Dad filed his petition forward, almost to Christmas that year, let's say June to Christmas, all visitation or contact between grandparents and children was cut off. So it was almost like we've had this relationship for 3 years and all of a sudden it's cut off. And Dad really, under the parenting plan, has no visitation, so there was an immediate cessation of visitation. So that intervention was allowed. The chancellor allowed some Christmas visitation for grandparents and Mom, or excuse me, and Dad, which went horrible. So we tried this case then in February of 22. And the court made findings, by the way, for the interim Christmas visitation, that she found that there had been a relationship with the children by grandparents for more than a year, and that a cessation of that relationship, and I'm quoting from the statute, the cessation of that relationship would cause irreparable harm, and so she granted the Christmas visitation based upon that. And jumping ahead to trial, counsel did agree and stipulate. It's interesting to hear the stipulation arguments in the last case. We didn't go that far, but Mom, through counsel, did not dispute that the grandparents should have visitation, I think is the way he termed it in his opening statement, and that really wasn't a source of real contest during the trial itself. In any event, we had the trial in February 22. The court made extensive findings, and those are recited again in my brief on pages 35 or 36 through 45, almost 9 pages worth of very specific findings by the chancellor. So basically the bottom line was that Mom was allowed to move to Florida, some 459 miles away. to move in with a fellow that she had met just a few months before they actually physically met in June of 2021. And then the next, according to the child, the older child, the next month they're packing to move in Florida with this fellow, with whom she developed a relationship online. So the court again awarded a parenting plan where dad would have 69 days a year, co-parent in Florida only, 1 weekend a month, Christmas visitation, and then 3 weeks in June, 3 weeks in July. The chancellor made, again, extensive findings. She said, although the findings, well, she didn't say, my take on it is, although most of the findings that the chancellor made were clearly against mother and in favor of not only dad, but his parents, she said, I want to give mom a chance. And very respectfully, that's no offense to her, that was her words. Importantly also, that all findings regarding credibility were in dad and his parents' favor and their witnesses. Chancellor specifically repeatedly made comments about the credibility of the witnesses and made that finding that dad was more credible than mom and that grandparents were more credible than mom. She also didn't place a lot of credibility on the older child, who was 12 at the time of trial, the little little daughter, and some of the things that she would say and repeat that seemed to have more intelligence to it than a 12-year-old would be discussing with the chancellor as a witness. So there was a motion to stay filed when this appeal was filed, and that motion to stay was granted by the chancellor, you may have noticed, and it was granted until the conclusion of this appeal, stating specifically that this was a very close case, Chancellor's words. No doubt that dad had developed a significant relationship with the children while he was with his parents during those 2 to 3 weekend times and Thanksgiving and Christmases together, some of which mom attended herself at dad's or grandparents' house. The grandparents were active with the children. They had a great relationship, picked them up from school, took them to school on Monday morning. Part of that was because mom was working. Mom had 2 or 3 boyfriends during the pendency of time between the divorce and the filing of this petition, one in California, one in Colorado, and now this latest fella in Florida. So I've already mentioned granddad testified very emphatically, I love the children love me. The first time they visited at Christmas, as you heard me say, the visitation went south badly. So basically, the little girl testified that we were already packing. They took us to court, and I got mad, so went downhill from there. The situation with the boyfriend that she moved in with is he's a long-haul truck driver. He's out some 12 to 14 days at a time, comes home for a 3-day weekend, then goes back out on the road. Chancellor made a finding that basically his home was in the middle of the woods. This isn't like moving to Florida on the beach somewhere. They lived inland and had a home basically out in the woods where he'd be gone for that period of time and they would be there to fend for themselves. So again, credibility was a key factor here. I think the court needs to look at. And so basically, what I think the court should look at to show that, and by the way, I do agree with Mr. Calfee's assessment that this is an abuse of discretion standard for the court, both as the grandparent visitation and as to dad's objection to relocation. The court needs to look at Exhibit 1, which was the report from the monitor at the supervised visitation facility where dad was going while this case was pending. He went there some 33 times. And Ms. Dye, her name, her report's Exhibit 1, talks about the profound effect that we say the move was having on the children and how it had turned the children, how something had turned the children against dad and grandparents. So you only need to look at Exhibit 2 then, which is a significant set of pictures from pre-petition times when the relationship was great. And so it's a 180 about face as to potentially now hate and alienation towards not only dad but grandparents.
Wasn't there a turnaround in that, and the court specifically brought that out, that there appeared to be a turnaround once she found out that was creating problems?
She didn't use those words, Your Honor, but her findings did indicate that, for instance, that mom had a hand in, well, excuse me, did you mean the chancellor's findings or the visitation monitor? Okay. That mom had a hand in potentially talking to the child about things that were going to happen if they got to move. The little girl even used the words, "Mom got a moving degree." I'm sorry, that's the way she said it. Mom got a moving degree. Ms. Dye had a talk with mom after some of these visitations where they were so hateful to dad, and indicated that, you know, this kind of whatever's going on at your home needs to stop. And after that, the visitation got better for a period of time, then it went south again. So, now.
Let me ask you kind of I guess a basic question. I mean, there seems to be, best I can tell, a disagreement as to whether or not the trial court, what it did with the grandparents.
Right.
Granted it, didn't grant it, didn't address it, or what?
And I, frankly, Mr. Calf and I were discussing this a little bit. I just frankly said, you know, a lot of the findings intertwine findings as to dad and grandparents. So in reality, she did make findings. She didn't refer to the grandparent visitation statute nor make any specific reference that this is dismissed. There is a paragraph in the order that anything not covered by this order is dismissed. Well, that would include the grandparent visitation petition, because she never really addressed that in her oral findings from the bench.
Well, the grandparents' visitation initially was intertwined with the father's visitation. He would only see the children when they were with the grandparents, weren't they?
Yes. But remember, on paper, court order, he had no visitation. But grandparents and mom were on the same page with keeping the kids while mom worked, for instance, going on vacations and things. And then dad became involved in that and had been involved with that for about 3 years, well, since the divorce in 2018. So yes, you're correct, Your Honor. And I want to mention that, you know, there are different outcomes here that really might not affect anything. If this court affirmed the move, let's say, what does that do to the grandparents' time? Well, they had a lot of time every month, a lot of time, 2 or 3 days every weekend, or 2 or 3 days, 2 or 3 times per month, which are weekends, I should say. So if you basically affirm the move, their visitation will be derivative of dad's, which is this 69 days a year, is what the chancellor ordered. And that's much less than they had before. Bottom line, I've just got a few minutes here.
No, your time has expired. It's running over time now. So,
all right, thank you.
Thank you. We're from the appellee. You still have your time for rebuttal.
Good afternoon. David Calfee from Bradley County Bar for the appellee, Krystal Carden. Starting with one of the questions Your Honor asked about what did the chancellor do with the grandparent visitation petition, and I agree that she could have done this in a cleaner way. However, I think that because the relocation issue was so overwhelming and important to what the ultimate disposition of the case was, she focused on the findings set forth in the relocation statute rather than referencing specifically the grandparent visitation statute. However, as we set out in our brief, if you untangle the findings that she made as she went through 36, 6108, and 106, she references repeatedly the grandparents. She references repeatedly findings that are required in the grandparent visitation statute. So we think the findings are there. At first blush, when I read Mr. Seller's brief, I scratched my head, and I told him this earlier, and I said, oh no, did she not do something that I thought she did? But I think that she did. As he said, we stipulated, and it was in our own proposed parenting plans, that grandparents would be supervisors for dad. We recognized that there was a relationship there. We recognized that they were going to play a part in this case no matter what ended up happening, whether mom moved, didn't move. So we stipulated that. The court specifically found that there was harm by the cessation of contact. She did that both in December and she did it again in February, so that's there. And then again, she hit on almost all of the best interest factors that are required under grandparent visitation statute. And then what did she do? Well, she adopted our proposal that grandparents would serve essentially as supervisors in a transitional period until Dad got through the summer of what would have been 2022. And then from there moving forward, the record is very clear. Dad attested to this on his own cross-examination. He had a good relationship with his parents. He was going to make sure that they continued to have contact with his parents, and there were going to be large blocks of time during the summer and otherwise where the grandparents were going to be people he relied on. And as I looked back through the record, there was no clear indication as to what his work schedule was, but it was obvious he was gainfully employed at BlendPAC at the time of trial, and he would be relying on them in some way. So in looking at this, both from the sufficiency of the findings, we think they're there. They could have been clearer, they could have been cleaner, but they are in fact there. And then as to the disposition of the grandparent visitation, again, this is an abuse of discretion standard, and I think if you look at the findings as a whole, the factual basis is there in the record to support the findings that the trial court made. She applied the law, even though she may not have been very clear that she was applying the law, and the decision that she made ultimately was within an acceptable range of outcomes here. Again, the relocation, because it was such a big issue, was going to dramatically affect what the availability of the children were. If Mom had stayed in Cleveland, based on the trial court's decision, not just on the stay, the children were going to be more available for both Dad and grandparents. Once the relocation was approved and the distance between the parties was going to be established at 400 and some odd miles, obviously, in most long-distance parenting relationships, that limits contact to school breaks, holidays, periods of time in which the children have more flexibility for travel. And the trial court also adopted our proposal that there be an allotment for weekends when Dad and or grandparents could travel to the state of Florida. So we think that the outcome that was reached on the grandparent visitation petition is there. We think the record reflects that, and we think that it was an appropriate exercise of discretion for the trial court. Now, turning to the relocation decision, obviously this was a situation in which many of the court's findings were very critical of Mom. They're there for your honors to see. My client heard them, and even though she may not have necessarily agreed with them, she understood and she took her beating during those findings. Most of those adverse findings were related to post-filing conduct and interference, as the court found it, with a relationship between Mom or children and grandparents or children and father. The court was also critical of the manner in which she chose to introduce the children to Dad. However, as we read through those findings, not all of
children to Dad or
to stepdad, I apologize, Your Honor, misspoke there. How she introduced the children to now stepfather, then fiance. If you look through the findings, though, however, the trial court was clear in that Mom had been the primary parent. She had been the primary decision maker. She attended to the children's medical needs. She attended to the children's educational decision making. She had done all of this, and in fact, the appellants on cross-examination uniformly attested and admitted that was in fact the case, that Mom had been parenting primarily and solely with these children since at least the time of the divorce, which at that point in time was some 4 years. And when the trial court made her ultimate decision, it was clear that that role with Mom as the primary parent, primary decision maker, was what tipped the scales in favor of relocation. This is an abuse of discretion standard. The trial court obviously applied the law correctly in this situation. Our findings are, even though we may not want to admit it, they are supported by the evidence in the record that was adduced at trial, and what she did at the end of the day is within an acceptable range of alternatives. Since the statute was revised by the legislature, we no longer have the bifurcated standard, and these best interest analysis are squarely within the trial court's discretion. Despite the credibility issues she had with mom, despite the credibility issues she had with the minor child who testified, and the questions that she had, she said very plainly, as Mr. Sellers put it, I'm going to give you a chance. And she, based on prior trial experience with me in her court, she said, your attorney can tell you what happens if you continue to alienate these children or don't obey court orders. There's been no indication that any of that has been at issue since the ruling of the court. Of course, we've been in a little bit of limbo now since we've been stayed, and mom has been in Cleveland now some 15 months after the relocation was approved. But we think at the end of the day, if you look at the record as a whole, the rulings of the trial court reveal that it is an appropriate exercise of her discretion in deciding this case. And I know I've got time left, but I'm not going to talk just to talk. I'll answer any questions anyone may have.
I hear none, so thank you.
Thank you, Your
Hear
Honor.
from the appellant rebuttal.
Let me kind of wrap it up on the grandparent side of this thing, that if the court reverses the chancellor or modifies that and denies the relocation, the grandparent visitation will take care of itself because it'll be derivative of dad's co-parenting in Bradley County. Now, and I say this very respectfully, this is a case where, very respectfully to the chancellor, my best argument is the chancellor's ruling from the bench and her findings. And Mr. Galfie candidly pointed out that many of those findings were against mom. And that's both in the relocation statute, where there's a list of, I think, 8 factors under 108, 36.6, 108. And in addition, the court then goes to the custody statute and goes through those 15 factors, goes through every one of them very specifically. So of those 23 some odd factors, I think 3 were in mom's favor. And the rest of them, I mean, we're going down the line, and I'm kind of sitting back thinking, I've got a winner here. You know, and no one's winners and losers. I'm being facetious, but then we get to however, or but, mom, I'm going to let you move. So here I am, Court of Appeals. Now, again, you know, when there's only 3 findings in mom's favor, and the findings that were against her are significant, whether they're post-petition or pre-petition. We think that this is a case where the abuse of discretion standard would allow this court to either reverse or modify the court's decision. Thank you very much.
Of course, thanks to both counsel. We appreciate your oral argument today and your briefs, and have a safe drive back down to Cleveland. If you would, adjourn court till